Hello and welcome. This is NTA Tuesday Live and I'm Cyril Stober. That no nation can realize its full potential without a strong judiciary is stating the obvious. Now the rule of law has no alternative and the judiciary is seen as the last hope of the common man. Now at the All Nigerian Judges Conference last week, President Buhari reiterated his administration's commitment to the rule of law, and he appealed to the judges to ensure speedy dispensation of justice and ultimately decongest overcrowded prisons. The president told the judges that the initial investigation of some judges was neither intended to flex muscles at the National Judicial Council nor intimidate the judiciary. Indeed, he said, Nigeria parades some of the finest and most incorruptible judges in the world. Tonight on NTA Tuesday Live, we turn our attention to reforms in the judiciary. And I must have to say this, that this program is unprecedented in the entire history of NTA Tuesday Live. And you'll get to know the reason why in just a moment, because I do not recall that we have at any other time had 7 heads of courts on this program. And so tonight we'd like to welcome to NTA Tuesday Live the Honorable Justice Babatunde Adejumo, who is President, National Industrial Court of Nigeria. Lord, thanks for being here.
Thank you.
Let me also welcome Justice Ishaq Bello, the Chief Judge of the Federal Capital Territory High Court. My Lord, thanks for being here.
It's a pleasure.
We're also pleased to have tonight Mr. Augustine Alege is a senior advocate of Nigeria, a member Corruption, Financial Crimes Cases Trials Monitoring Committee, and a former president of the NBA, the Nigerian Bar Association. Thanks for being here tonight.
Thank you very much for having me here.
And also joining us tonight is Otumba Sonya Ogunkwade. He is a former special assistant legal to a former National Security Advisor General Serki Mukhtar. He's a private legal practitioner right at this time. Otumba Sonya Ogunkwade. Thanks for being here.
Welcome.
All right, let me acquaint you, as we always do, with the process of this program. At the appropriate time, you can get to be part of it all. You can join in the discussion in the studio. The various platforms will be on your screen. We advise you take advantage of them. However, for those who will be calling in, we say this every Tuesday. For those who will be phoning in, when your call gets through at the appropriate time, do us a favor. Turn down the volume of your TV set. Just reduce the volume. That way, we will avoid the hurlback or the echo. And let me just say this, the best way to know that your call has been passed through to the studio, you'll see a name on screen. Once your name appears on screen, it means that your call is through, and we encourage you to just go straight to the point, ask a question, make a comment, but just keep it short and straight to the point so that more people can get on the platform. Once again, welcome to NTA Tuesday Live. This, like I said earlier, is a special edition because we'll be looking at the reforms in the judiciary. But let's start off right away by beginning with Justice Babatunde Adejumo. My Lord, let's look at the question of judicial reforms. What are the areas that we should be focusing on here?
Thank you, Silver. There are a lot of areas we're looking at, but specifically, I would like to say that look at the areas that are part of the reforms agenda of the present headship of the Nigerian judiciary, His Lordship Honorable Justice and the Chief Justice of Nigeria, Chairman of the Judicial Council. When he came, he looked at the area of decongesting the courts with overfilled dockets, hanging on for many years. He came up with the performance evaluation, improvement on the performance evaluation of judicial officers. He came up with an idea of bringing an innovation to the procedure of appointing new judicial officers, because the best way to have better judicial officers is to start from the entry point. He believed in that, and also believed that the welfare of justices and judges should be looking to particularly in the area of residencies, court halls, and all the rest. And we also look at the area of how judges can be put under check if any of them is found wanting, and a lot of others.
All right, we'll return to some of them, but let's come to my Lord Justice Ishaq Bello, Chief Judge of the FCT High Court.
Thank you so much. Well, one doesn't have to repeat what my brother said. He was saying the obvious. But I'm looking at it from the point of the committee set up by His Lordship in line with this reforms agenda. That is the Committee on Corruption, Other Crimes, Cases, Trial Committee that will oversee some of this corruption trials before the various courts. I see that committee not just from the point of its mandate, but I congratulate His Lordship for doing that on the premise that this is the beginning of a journey outside the box. For long I have been worried that the executive, the legislature, and the judiciary have been unnecessarily and so rigidly territorial. Each one reduced to its compartment as created by the Constitution. No any visible synergy, so that there is a kind of working relationship, any specific forum that will bring the three together, when in fact they are brought together by one thing, that is nation building. Because whatever the executive does, it is intended to enhance and facilitate nation building. And so the legislature and the judiciary, whatever you call any of the three arms. So this unnecessary territorialism has hindered a lot of meaningful developments. So for the CJN, be responsive to public outcry, because that is what he said at the inauguration of the committee, that it is obvious the public is not satisfied and is disenchanted with the performance of the judiciary, and therefore it is not wise to dismiss as mere sentiments some of the outcry. So the composition of the committee indicates the beginning of the judiciary opening its doors, embracing the public for them to see by themselves what are the problems bedeviling the justice system. I hope it will crystallize ultimately to the establishment of a forum that will lead to consultation conscientiously between the three arms, so that backpassing at the public domain, criticisms and attack will be over, because by this contact you'll be able to understand what are the problems bedeviling the prosecution, which is the role of the executive. What are the problems bedeviling the investigative process, which is the role of the executive? Why is it that bills sent to strengthen legislation or acts that are being operated or guiding the adjudicative roles or any other prosecutory agencies are delayed? They are not getting the promptitude with which anybody will expect them to be attended to. This will bring a database upon which either the executive, the legislature, or the judiciary will be able to say, this is the destination, this is the direction of the nation, and we must all bring hands together so that we move towards realization of the dreams. Now, coming back to the reforms specifically, a lot have been put in place. The issue of the congestion of prisons, when recently the government, through the Office of the Attorney General, decided to set up a caretaker committee for the purpose of decongesting the Nigerian prisons nationwide, the Honorable the Chief Justice embraced it wholeheartedly and encouraged that there should be active participation of the judiciary. And he, without mincing word, he contacted all the respective heads of courts all over the country to make sure that they give necessary cooperation to the committee. It happens that I'm the chairman of that committee, that we will go around in collaboration with the respective heads of court as various states of the Federation to ensure the congestion of prisons nationwide. So many things are there. The issue of disciplinary measures, even to lawyers. Lawyers, added lawyers, senior advocates, others, starting of the lawyers, will be punished when they misbehave in court, either failure to attend or any form of misconduct. These and many other things are there, and in the course of this discuss will unfold.
Thank you, my lord. Well, let's come to the former president of the NBA, Mr. Augustin Ligge. And of course, you know, there's been so much about the bench, the bar, and virtually the same things that are said about issues happening in the courts are also attributed to a large extent how members of the bar conduct themselves in all these cases. So let's talk about the reforms from your perspective.
Well, thank you very much, Cyril. Reforms on the judiciary have been ongoing for a long time. Various heads of the judiciary at different times have tried to embrace reform the way they saw it best. Well, like my Lord Honorable Justice Ishaq Bello has said, CG of FCT, this is the first time that we are having an open arms approach, where you're allowing the Institute of Chartered Accountants of Nigeria, you're allowing the Nigerian Medical Association, you're allowing non-governmental organizations to come in and work with the judiciary to see how things are done and how things can be done in a better way. From the perspective of lawyers, lawyers essentially are the engine room of the judiciary. They are the prosecutors, they are the defense attorneys, they are for plaintiffs, they are for defendants, and even my lords who are here are lawyers themselves. So there's no way you can deal with reform in the judiciary without also dealing with reform of the bar. You must also realize, like Honorable Justice Adejumo said, that it is the bar that feeds the judiciary. So if you have discipline of the bar, then you're going to feed in disciplined lawyers into the judicial system. From the perspective of the bar, I know that the bar is doing its best to be very responsive to the challenges that occur at the bar. We have a very active and vibrant legal practitioner disciplinary committee. In the last 4 years, more lawyers have been sanctioned than were probably sanctioned in if you put 4 years aside, take the last 50 years. We have more panels investigating issues against lawyers. I know that the disciplinary committee at times sits till 6 p.m. At times they take 50 cases in 2 days. So it's a holistic approach that has been adopted now. While the judiciary is taking steps, the bar is taking steps, and I believe that the good works that are being done are beginning to bear fruit. People are beginning to see that there's positive change, but it's difficult. You know, when you are deep in a hole, even if you rise up halfway, you are still not at ground level.
Right.
So that's the challenge we're having now. People are still looking at when are we going to get to ground level. But in all honesty, we're no longer at the bottom of the hole. We are climbing out gradually. And I think if these efforts continue, in no distant future, we'll all be very proud of our judicial system.
And of course, it's still the public perception that issues to deal with the judiciary, the bar and the bench are sometimes shrouded in so much secrecy that to members of the public who are, as the lawyers say, who are not learned, they see something like a kind of a cult. Now, with what we are talking about here now, the opening up and then bringing these institutions to the public glare as to entrench transparency, what are your perspectives, Mbasa Mukwadi?
Personally, I think from my experience in practice, I don't think there's any secrecy in advocacy. There's no courtship, there's no anything unbecoming in the relationship. Most importantly, it's just like my learned son had said, the people sitting at the bench and the bar, they are all the same. The judges are lawyers too. So relationship must continue. And as a matter of fact, for those people who are not lawyers, when cases are decided, they look at it as if it's a magic. Judges are not, they don't fall down from heaven. They are fed with facts presented to them. And they live on facts. They judge based on facts. They are not like, you know, maybe the oracle at Ife that will proclaim one Oba after the other by just tossing the coin. So, but like for instance, maybe case of theft, the law prescribes what must be proved. And there are lacunas. I mean, not lacuna. The defense, the prosecutor failed to present to the court the necessary essentials. The judge cannot do any magic. Because if he acts contrary to that, he'll be doing injustice. So it determines a case according to the facts presented to him. There are many cases where lawyers really mess up the case of the client. There are many cases where, because of the incompetence of the lawyers, clients are sent to jail. Even some are sent to the gallows. Some lose their properties. Ultimately, all he can do is, I leave it to God. Because the judges are not gods. They are human beings. They are my Lord on earth. And they judge based on conscience and facts presented to them. So there's nothing hidden at all about it.
Yeah, but since we're in that subject, I might just tarry a while on that, because you just raised the issue about cases in court, and this also is part of what we see when we talk about public perception, and facts are presented. For one who is not learned, it would seem to the ordinary man, the ordinary citizen, that, look, this is so clear. And then you have issues of technicalities coming in. People are in court, and at some point in time, people who go to court are wondering if there isn't some kind of collusion between judicial officers. These are some of the things that the public worries about.
Can I come in? People may come in. Right. If I can come in on this issue.
Right, my lord.
Well, he has said a lot about what the public holds as a perception, that maybe there is courtism or there is secrecy. There is no secrecy, either between the bar and the bench or the bench per se. I will take an example. The public perception about the National Judicial Council is that they protect themselves, that judges are the ones they complain against. Most people there are also judges trying to investigate this issue. What do you think you can get out of it? I think it's a wrong perception. Like the former president of the bar has just said, within the last 2 years, the number of judicial officers that have been recommended for removal is more than the ones that have been recommended for removal for about the past 25 years. The problem the council has is this. There are many, and very few. For time will not allow us to go into details. One, you petitioned against the judge to the council through the chairman of council, who is the Chief Justice of Nigeria. We have procedures. There is the preliminary investigation committee set up by the council to look at your petition and to see whether there are prima facie issues in your petition which will warrant the judge to defend himself. If the committee comes out with 1, 2, or 3 issues that he has to explain, then we report back to the council. The council will now put up a panel of 3 heads of court or other member. The judge will come, the petitioner will come as like a semi-court. The petitioner will be asked to go to the boss, swear on whatever he believes in or she believes in, now adopt his petition, he will be led by his lawyer. He will be cross-examined there. After the judge will also go into the box after being sworn. He will be led by his counsel. He will be cross-examined by counsel to the petitioner. The counsel will now look at, they will file written addresses. We sit down, we look at the merit and demerit of this petition. If there is any case of misconduct, misconduct does not limit to corrupt practices alone. A lot of things as defined by the practitioners, judicial officers, code of conduct. They are there, they are spelled out, and they will report. If it's to be removed, then the plenary will adopt the report, debate it, agree on it. A plenary meeting of about 27 eminent Nigerian and always chaired by the Chief Justice of Nigeria. And you can see at times they may disagree with the committee's recommendation and appoint another committee or decide on its own to come in the plenary. But the problem here lies in some cases with the executive. I can think without missing words that we have more than 6 cases that we have recommended judicial officers to be removed by either the president or the governor, as the case may be, that as I speak, for more than 2 years, they have not been removed. Now, the council said, for 3 months, then we came up with the council that if for 3 months after recommendation, the judicial officer is not removed, we stop paying his salary. But still, the executive at the federal state level are still finding this very difficult. 2, some petitions are ordered on issues that appeal should have been the rightful thing to do. The council is not a court of law. It is an executive body created under Section 153 of the Constitution and Section 21 of the third schedule to the Constitution. Now, if you are raising issues, oh, he did not give me judgment. I said I wanted extension of time. He refused. He did not admit this evidence. The council is the wrong place to table your petition. You go to the appellate court, who will look at your problem. Then the council says, no, this is not for us. And again, it is like what, again, my friend, the former president, said. You write a petition. They set up a committee to investigate. They set up a panel. The panel had worked only to conclude. The petitioner will come and say, I'm withdrawing my petition against the respondent judge. Once he has withdrawn his petition, what is next? But still, the council thought that would not be all. Even if he has withdrawn, if there's an element of misconduct, the council now amended the rule to say that issue of misconduct, if he didn't give judgment for within 3 months, and you say I withdraw it, he has committed something, an infringement of the provision of the Constitution. Just all to see that things are done the way they should be done. But the public, because of what happened recently, maybe at the beginning of this year, thought the judiciary led by because the national judiciary is the highest judicial body, policy making body and disciplinary body of the Nigerian. I thought it's a wrong conception to have that perception that the NGC or there's no secrecy, there's no courtesy at all.
Right, well, if I may come in at this point, I think the short of it all is that my brother is saying the NJC is very firm and stiff when it comes to subjecting judges to reprimand, appropriate punishment in the face of any misconduct. Now, what the public should understand is that, like the policeman who has been tried orderly room, or a soldier who had been tried by their own procedures, both are not insulated from being prosecuted in the ordinary court, just like any other judge. All it takes to appreciate the position of the judiciary in developed nations, because of the institution, you allow the mechanism put in place by law to take its process of finding culpability and then subjecting that judge to appropriate penalty as provided under the in-house mechanism, then he is released to be tried before the conventional courts. No more a judge. Just like out of the orderly room, he is removed from the police, and when he appears in court, he is not seen as a police officer because of the institutional protection, the image of the institution. Now, that is just that. Coming to the earlier segment of the issue you raised, that is delay in courts and technicalities, agreed. Some of these delays are brought by undue technicalism. But I can tell you, there's a radical departure now from the old order. Quite a number of practice directions are coming into the stream, addressing those areas of lapses, blocking the holes, so that cases will flow. The recent pronouncement of the Supreme Court in line with that is that there will be no stay of proceedings in the face of any interlocutory appeal. Now, which has been the bane, the central issue, bedeviling smooth conduct of cases, interlocutory appeal. Whichever way a judge decides, a lawyer that desires to frustrate the matter will file an appeal because constitutionally it is provided that he's entitled. That is a constitutional provision. And the trial judge cannot say no. Now, particularly when the appeal is entered in the record of the Court of Appeal, plethora of decisions from the appellate court is that you must hands up. Now, we are beginning to realize the need to avoid that even without constitutional amendment. We went international trainings, we have observed international best practices, like in Singapore. Even without constitutional amendment, the synergy between the trial court and the appellate court, as always, is that come before the appellate court with both the interlocutory issue and the substantive decision. No matter what objection you are raising, that has eliminated delay. You cannot go before the appellate court without the decision in the substantive matter. That you have foreclosed delay. If the intention is that by delaying, maybe some of the witnesses would have died or disappeared, you pay them to go to a different destination and relocate, or certain documents are hidden, you have already foreclosed that by insisting that both the interlocutory issue and the substantive matter must go to the appeal court together, as we do in tribunals. I have presided quite a number of election petition tribunals. No matter what objection you have at the outset of the matter, whether it is jurisdictional or anything, competence of the matter, you have to go along with the hearing of the main matter. No party is allowed to go out of the court without ventilating his mind. And that is what we are doing now.
Right, my lord, for people like us, for instance, we've seen cases where this part of it will come to Mr. Legge to comment on it. But let me just stay with you a while. The public, we have seen cases where issues that were supposed to go through the court or maybe trials, people are getting injunctions and in perpetuity, perpetual injunctions, saying, look, you cannot take me to court, try me for such and such and such a thing. And this is happening, and people are saying, these are some of the failures in an anti-corruption fight, for instance.
Yeah, you see, whether one likes it or not, one has to believe that some of these lapses are dictated by systemic problem. If the Constitution has provided for interlocutory appeal, what can a trial judge do when a lawyer chooses by all means to go on appeal to a superior court? You can do nothing. You have to hands up, except for now. The Administration of Criminal Justice Act expressly provides that there is no stay of proceedings even when you appeal. You can see systematically, by way of amending, improving the system, we are moving closer to the desired destination. Now, you see, when we talk of administration of justice, people only look at the judiciary. I can tell you, 60% of administration of justice lies with the executive. And I can convince you on that. it is only 30% you can attribute to the judiciary. That is adjudicative responsibility. It is solely resident in the judiciary. But when you come to administration of justice, it's a broader base issue. You start from the issue of allegation, which is to be investigated by the police. The judiciary does not have police to investigate, or any agency that has, by law, both investigatory and prosecutory powers. It's not residing in the judiciary. It's the executive. If there is poor investigation and the matter comes to court after all the hue and cry through the media, either print or electronic, high expectations are built up, yes. And at the end of the day, nothing comes out of the investigation, and once the judiciary throws the matter out, oh, the judge has been seen. And if he is like me, who would want to look neat for my own personal satisfaction, they will say, oh, he has been seen. I will never go wretched because for fear of anybody thinking that I've been seen. Let me land. If it is Indian hymn, I hope one day you take your team to go to the lower court where Indian hymn cases are tried. How many forensic laboratories are here and are in this country effectively functioning? If anybody who decides to be mischievous gets ogu lip or bitter leaf and throw into a car, and then you are arrested for being in possession of Indian hymn, may God save your neck. Yes. Only God knows when the result of the scientific report will come out from the forensic laboratory that is hardly functional. And there you have ballistician specimens for examination, you have DNA problem, you have handwriting specimen for analysis, for report back to the judiciary, respective judiciaries. And if all judiciaries of the nation lead to 1 or 2 forensic laboratory, how long do you wait? And it's not part of the judiciary to provide for this. So the prosecution, the investigation may be splendid, and if you don't have a prosecution with skill that can marshal the facts and the legal framework to place before the court, the case bangles. Now, that is why I'm telling you, 60% resides on the part of the executive. Ultimately, if the matter concludes and the convict, assuming there's conviction, gets to prison, fair enough. The reformatory facilities, are they there? I have been going around the prisons. I know what is there. Very lamentable. We sympathize. You see, we're here to just call a spade, so that the nation can move forward. It's not about persons. We own up that there are lapses in the judiciary, and we are making amend, but we suffer accusations that are not rooted in the judiciary.
Just before you go to the president of the Republic you have indicated, I would like to say that Nigeria is one of, or this is the only country I have been to, that the security agencies, which are part of the executive, will arrest a person, arraign him before the court, seeking for an order of court to remand him before looking for evidence. In more civilized climes, recently in England, on their BBC, they've been trailing a man for 2 years. When they got the sufficient evidence to nail him, it was then they picked him. He could not even deny it again. And it was easy for the court to do its own job. But in Nigeria, the reverse is the case. I think, like my brother Ishak Bello, the CJ FCT, has said, we have to start from the executive. Because if they fail to do their job, it is an opportunity for the defense lawyer to do that. And again, talking of public perception about whether the judiciary is being reformed or not properly, either it's a cult or not. There are 2-3 cases of recent. After, just to suppose he said that the in-house mechanism should be allowed to take its course. All right. After we have found at the NJC that 2 judges, one in Kano, one in Safara, already committed misconduct, the council recommended that and prosecution by the prosecuting agencies.
All right.
Hitherto, they have not.
Well, I did say it would come to you, but we have a caller who's been waiting on the line now. Emmanuel is calling in from Abia State. That's our first caller tonight. Can you just go ahead, Emmanuel, and go straight to the point? Hello.
Hello?
Hello, go right ahead.
Good evening.
Yeah, good evening.
Yeah? Hello, good evening.
Good evening, Emmanuel. Go right ahead.
Yes, yes. I love your program so much. Yes. Yes, I love your program so much. And you are doing well in your... Yes, yes. You are doing well in your reforms and other programs that involve corruption. You are doing well. But I want to know that if these judges, these people who I'm seeing here now, if they have some other problems, they can go for public hearing so that others can assist them. For the judgment that they rendering to me personally are doing well. Because some of the judges, some of the judgment they render, you see a lot of people applauding what they do, saying that they did a very fine thing. And I think that people who are attacking them are not doing well. Because it is people who hate the judiciary. Judiciary is doing wonderful things in Nigeria. And I praise them so much. But if they have problems, they should come for public hearing so that people can bring their opinions, so that anything that is good will be shown to the public. Just like we are now hearing you now.
All right. Okay.
I love this. I'm the state chairman of the state, and I love what people are doing. Continue with your program. It's very nice.
Okay. Thank you very much, Emmanuel. Right, let's come to you.
Well, Cyril, firstly, we spoke about the NGC now.
Yes.
And we spoke about now inviting ICANN, but the law and the constitution of the NGC, we already have the public as members of the NGC. Right. There are two persons representing public interest already in the NGC. Certainly, we cannot expect all 150 million, 170 million Nigerians to be members of the NGC.
Right.
After every NGC meeting, the NGC issues a release as to what transpired at the meeting. The challenges we currently feel that a lot of people do not listen to what the NGC is saying. Recently, we've had people who have written petitions. Your petition should be accompanied by an affidavit verifying the grounds of your petition. I know NGC took pains to make publications in the papers to draw people's attention to all of these facts. And a lot of people seem to be lost on this. Definitely, we have challenges in the judiciary. We do not run away from it. But we also have the tendency that, where I would disagree with my Lord, Justice Shagbelo, no lawyer can appeal. Only the client can appeal. For me to file an appeal on behalf of a client, he must pay me a fee. So if he has a grievance, and I say I want on my own to go and file an appeal on his behalf, who pays the filing fees? Who pays my legal fees? So when lawyers file appeals, file for injunctions, they are doing so on the instructions of their clients.
Right, but may I just ask this at this point? At what point would you, as a lawyer representing, your client, believe that what he's asking you to do might amount to an abuse of court process?
If a man, my lords are here, is charged, for example, with a capital offense, and he has told you that he killed a man, and he comes to court and he pleads guilty, my lord will record not guilty for him. Because that's what the law says.
Yeah, because it was you he told.
No, even if he comes before the judge in a capital offense.
Of course, procedurally, yes.
For capital offenses. I'm just giving you an example. What the police do not understand. That even in a capital offense, and the man says, I am guilty, I killed the person, the judge has a duty to record a not guilty plea and get the prosecution to prove. There was a case of two lawyers who were traveling and had an accident, and they killed somebody, and the villagers burnt the lawyers to death. And no lawyers agreed to represent the villagers. When they got to the Supreme Court berated the lawyers. You must represent them. They have a right to counsel. The mere fact that they killed your colleagues, it does not debar them from representation. Thirdly, I say this to you. If there's no lawyer for the defense, the state has a duty to appoint a lawyer. So even if the man is thinking with guilt, for there to be due process, he must have a lawyer, right, which is one part of the story. Right. The second part of the story is that as guilty as you think he is, if you're unable to prove his guilt, he walks. And then we'll move to the next level now. In other crimes, what happens is, because the average policeman does not know the essential ingredients in establishing guilt in a particular offense, when they are doing the investigation, they are assigned a lawyer who says we need to prove item A, item B, item C, and item D. This is what happens in other crimes. What happens here? The policeman who does not know what he needs to prove goes head deep into the investigation. At the end, he brings a file and dumps it on DPP. And DPP files the charges. The DPP, none of them have told the man, you need to bring the murder weapon. You need to do a test to show that the blood on the murder weapon matches with the blood of the victim and of the accused. So the man comes forward with a bloody dagger, no DNA evidence, no blood match. And if you are, and the law is that, let us take criminal offenses, for example. A man who is charged with a criminal offense is entitled to every available defense. So if you are defending him and you are taking a professional charge to defend him, and there's no DNA evidence linking him with that murder, will you say because you believe he killed him? He will still tell the judge, my lord, there's a dagger, no doubt. There's blood, no doubt. But there's nothing to show that the blood there is the blood of the defendant. There's nothing to show that the blood there is the blood of the victim. So you see, like Honorable Justice Shaka said, the judicial sector should never be seen as lawyers and judges. It is a whole sector that should work collaboratively to ensure that we have justice in the system. Justice for the victim, justice for the accused person.
All right. Sorry, it's very important for the public to understand why should a judge enters plea of not guilty even when the accused said, I have committed the offense.
That's for capital. No?
Yeah. The reason is that the law attaches a great deal of sanctity to human life. So for anybody to be alleged as having killed someone, the law will start suspecting abnormality around him. So the necessity to say he is not guilty. But it's not for the judge to raise the issue that maybe he is mentally retarded. No. You put not guilty there and allow the proceedings to progress. If in the cause and a defense of insanity is raised, then it has to be supported. Otherwise, at the end of the day, the evidence is established truly he is guilty and you convict him.
Sorry, before you go too far, we talk of this issue of delays at trials. Yes. And the whole idea and the concept is that it is caused by defense. But the new Administration of Justice Act has placed an obligation on the prosecution and on the defense. If the judges apply that law to the letter, all these cases that we currently have pending will have been struck out because the time specified for the prosecution to present their case, in most of them, have lapsed. Okay. Prosecution is still arguing issues of bail. Prosecution will not bring the accused persons to court at times. So that's why we keep saying that it should not be a blame game.
Right.
No.
We should look at everything holistically and approach.
Okay, let's go back to the phones now. We have Usman who's calling in from Abuja. Hello, Usman. Go ahead.
Hello?
Hello, Usman.
Yeah, good evening, sir.
Good evening.
Yeah, good evening, my lord. Hello?
Yes, go ahead.
Yeah. Well, on the issue of fighting corruption or losing cases of corruption, I think, to my understanding, most of the cases are lost on technical grounds and not on the basis that there is no evidence, but on technical grounds. Now, one wonders, for example, the case of Ibori, there are charges preferred against him by the EFCC. All those counts from the first count to the last count were quashed. And I don't think he even appeared in the court to take his plea. The whole count were quashed. And the same charges, the same evidence that was supposed to be presented before the court were used in London to prosecute him. So one wonders, what is the problem with our judiciary? The fact that technicality is being considered much more than the evidence. And of course, that is why even the law is said beyond reasonable doubt, which means no matter how you are going to investigate that case, there should be some element of doubt in what you will do, because you cannot prove your case 100% because no human being is perfect. That is why the law says beyond reasonable doubt, not beyond absolute doubt. And another thing, now look at the issue of that happened in Rivers State. Perpetual injunction given by the judiciary to former governor of Rivers State, Peter Obi, and up to date, nothing could be had. Now, my thinking is that because his wife sits in Supreme Court, that appeal will never see the light of the day. So, in this case, how would the judiciary? Now, I really want my Lord to educate me on this issue because it's worrisome. How can somebody be given perpetual injunction? Don't arrest, don't investigate, don't do anything as against a constituted authority that was a body like the ATC that was created by the National Assembly to investigate such a person. And with this kind of person having his wife in the Supreme Court, how possible can that not be prosecuted?
All right. Thank you very much, Usman.
It's a very good one. I have not read the decision regarding the charges in relation to Ibori and what led to the order for perpetual injunction. But what I can say is that as a judge who had risen from the magistracy to the position I am and been in criminal trial for ages, of recent we are witnessing inelegance in drafting charges. Right from the outset, you get worried. You don't require 100 charges to get to your dreamland. You see, we tend to look back into the military era where people are sentenced to 100 years, etc., etc. If I have reason to convict anybody and sentence him to 1 day in prison, the word convict has its own stigmatizing effect, permanently depriving him to so many civic rights. But I don't know how our psychic has remained attuned to wanting to have 100 years imprisonment. Just some few days I was meeting with my members of the caretaker committee for the congestion of prison. About 68 billion naira, which is not enough, is meant for the running costs of the prison, feeding inmates, convicts and awaiting trial alike. 68 billion. And that is a budgetary projection that is not even enough for the prisons. We are clamoring for prison decongestion. And people are not satisfied until you sentence somebody to 100 years in prison. Assuming that is something to be done sustainingly, the charges, they need to be tutored on how to draft charge. any charge that is afflicted by duplicity, vagueness, by law, is susceptible to being struck out. As I said, I don't know what transpired in Ibori case, but from the general things we are seeing today, with our experience on the bench over the years, the inelegance in drafting charges, and we are just talking about the investigatory process, and that is part of it. There must be willingness to invest very much in investigation and prosecution, as well as adjudication.
Yes.
The Administration of Criminal Justice Act expressly provide non-arrest until after the completion of investigation, so that we can emulate international best practices. But on another breath, knowing our own peculiar circumstances, it also provides for arrest and seeking remand pending completion of investigation, the same act. Why? Because unlike in international communities, your neighbor will be the one to report you. He will be willing to volunteer information. Here, even when you are enemies as neighbors, when he sees the police, you say, hide, they are coming. He is not willing to come forth. The difficulties in investigation, etc., etc. So we find ourselves compelled to give a remand order. And you see, the Act intends that police or prosecutory agencies should perfect in administrative bail as it is done in overseas. But it has now become a culture, routine. Every situation there must be remand. There was never a time they will come and say, we are here ready to prosecute today to start, because the provision has provided, the Act has provided for the right to seek remand.
Oh, okay, let's quickly go back to the phones. We have calling in. Well, we've lost that. We've lost that call. Okay. All right. But
quickly, please.
Yes.
The CGFCT have said something about all these procedural problems. Another serious one is still with the executive. They prefer 10 charges. When they get to court and the case is started, they see the handwriting, they seek an adjournment, and now bring 30 charges. The defense counsel was okay, I'm asking for an adjournment to react to the new charges framed. So the case will continue to be delayed.
Okay, madam. Well, on the other hand, part of the delay in administering justice sometimes is seen as beginning put at the doorsteps of the lawyers themselves. At what point? Yes, there are professional ethics, there are codes. At what point would a lawyer now seek to exploit a loophole somewhere and extend a case which ordinarily should go on trial? Because it's been said it's happened so many times. And even as the senior advocate said here, even where your client has confessed to you that he has committed the offense, you still enter a plea of not guilty. Or if they
for capital offenses.
Yes, for capital offenses.
Yes.
And if they're unable to prove by way of even when you know within yourself and he has told you in confidence, you still go ahead and say, well, he's not sure.
No, what I said, not even in confidence, even if he says so in open court.
In open court.
The prosecution must still prove.
All right. Okay.
There are so many issues, but I think I'll just restrict myself to the last you put to me.
Yes.
You see, we have criminal cases, we have civil cases. For criminal cases, capital offenses, even where there is an admission of guilt, the law says it must still go through trial. Just like my lords have said, and the learned son. You see, but in civil cases, it's a different thing. It appears we are concentrating on criminal cases only.
All right.
I think the bulk, the bulk of the cases are civil. You cannot compare the number of civil cases with that of criminal in our courts. You see, everything again depends on conscience. For non-capital offenses, where somebody confesses to you as a lawyer that, yes, I did this thing, and you know the evidence is like strong enough, like what did you tell the police, what are the things they got from you? Sometimes you may just tell him to admit and plead leniency. There's no point you have to elongate these things. I think it's a question of conscience. For about 35 or 37 years, I've been in practice. I think.
What if the client comes to you with, well, you have your professional fees, and he says, look, no matter what the situation is, I'm willing to go on an appeal, and I'm putting in X, Y, Z, which
right.
is what people see most of the time, that as long as you have a deep pocket, you can stall a case for years.
See, I think we have to be very, very, how do I put it? We have to put in good conscience in whatever we do.
All right.
We have to also consider the issue of...
talking about reforms.
Yes.
What you are saying now, I know has been the practice,
yes,
but it's been addressed by the systemic changes now being introduced.
So this will affect, will address this.
No doubt about that. I can tell you, with the understanding and encouragement by the Honorable the Chief Justice, we have put in place in the FCT practice direction,
right,
that will implement to the letter the Administration of Criminal Justice Act. And I can tell you, quite a number of states are already adopting the practice direction alongside the Administration of Criminal Justice Act because of the revolutionary provisions there. Just from yesterday and today, my judges went through thorough training on the practice direction, the magistrates, including registrars. Now, what we intend to do to demonstrate that there is now a radical change, as encouraged by my Lord the Honorable the Chief Justice, soon after the New Year, I'm going to put in place 3 panels, each comprising 3 judges, another 3 panels, each comprising 3 magistrates, to address the heavy and overloaded dockets of the various courts, with a view to decongesting the prisons. And I can tell you, I had written a letter to all the prosecutory agencies, including the Federal Ministry of Justice, 5 months ago, that any matter they think is unprosecutable for want of evidence, they should compile, come and have them struck out before I put these panels in place. By the time we return after the New Year and I put these panels, we will no longer tolerate the overstretching of judicial tolerance. What judicial tolerance entails is that in major sensitive cases, we keep on bending backward. We keep on bending backward, adjourning, and they capitalize on this. Either the investigation is not completed, they continue to take adjournments, particularly cases where the defendants are in prison. They keep on taking dates, and we keep on bending backward, because when we release, it is then the media will descend on the judiciary that the agencies are working to cleanse the society, the streets of crimes and criminals, and the judiciary is releasing them. We are not going to listen to that. I will have a meeting with all of your people, the NGOs, and my team for the congestion of prison. We'll be there when I will launch these panels. And we are going to discharge those people. If they arrest and come back, we'll give them timeline to prosecute those cases. It is only then we will be able to decongest the dockets and the prisons. I can assure you, once we do that in the FCT, other states will follow.
All right. Well, I wonder if we still have the caller from Suleja still on the line. Is he still there? Right. Mohammed from Suleja, just go right ahead before we take a quick break. Mohammed, go ahead.
Good evening, gentlemen.
Good evening.
Yes. I want to contribute a little. I want to thank Mr. President to give the judiciary free arms, free hands to work. And we want to thank the Chief Judge of Nigeria. And we want to thank...
Yes, Mohammed. Mohammed, are you still there?
Yeah, secondly again. Well, the judges are doing very well, but who destroy the works of the judges most of the time is the lawyers. They collect a lot of money from clients, which they give bribe to the judges so that they win their cases.
Okay. All right. Okay, so fine. Thanks. The lawyers are here. We have our senior advocate here, and he will address that. So, thank you very much, Mohammed. At this point, we'll take a short break. When we return, we'll look at other perspectives and see what other reforms are taking place. We'll also take the cameras out to the streets and hear what the citizens have to say. But just before we take that break, there's a very brief tweet in here which I'd like to take just as we go on break. And it is from Oluseyi Otunuga. And he says, our judiciary has a lot in the fight against corruption. He said, and like my Lord said, one day conviction is enough, but hope the executive will not use phony presidential pardon later. We'll take a break. We'll be back shortly.
Securities and Exchange Commission (SEC) hereby informs the general public that shareholders that are yet to register for the ongoing free e-dividend registration should approach their banks or registrars to mandate the bank accounts for the collection of their dividend electronically, including unclaimed dividends not exceeding 12 years of issue. The free registration sponsored by SEC closes on 31st December 2017. Furthermore, investors that bought shares of the same company during public offers using different names are given forbearance up till 31st December 2017 to approach their stockbrokers or registrars to regularize their shareholdings in line with the Securities and Exchange Commission's rules on customer identification. Thereafter, all shares not regularized shall be transferred on trust to the Capital Market Development Fund. These are part of the Securities and Exchange Commission's initiative to further improve investors' benefit and confidence in the Nigerian capital market.
Nigerians, our fearless officers and men of the Nigerian military are winning the war against Boko Haram. Today, all occupied territories have been recovered and Boko Haram has been degraded. Our affected brothers and sisters are getting their lives back. However, they are now after you and me. In our mosques, churches, schools, motor parks, markets, entertainment centers, and public gatherings. Be vigilant. Be security conscious. Report suspicious persons, objects, and movements to the police and other security agencies. The security of our nation is a duty for you and me. Nigeria, unite against terrorism.
This message is brought to you by the Federal Ministry of Information and Culture.
The struggle for independence had been a long and tough one. Our founding fathers and compatriots sacrificed their comfort and even shed their blood. We cannot at this point in history afford to spirit away their sacrifices for immediate but temporary gains of today. Let us emphasize what unites and not what divides us. Working for the unity of purpose with a stronger vision for a better tomorrow. NTA, growing with the nation.
Nigeria, the only country we can train with remarkable potentials to excel. Let us believe in ourselves and change our attitude for the sake of our country and generations unborn. Let us revive our cultural values, which are our essence as a nation. Let us renew the spirit of patriotism and hope in our dear country. Do not take or give bribe. Be punctual always. No more African time. We can't expect to be global citizens and operate on African time. Join the queue. Insist that people are attended to on a first-come basis, no matter who they are or where they come from.
Nigeria, good people, great nation.
Make you report any crooked person, object or wakajube movement to police and security agent demo.
The security of our nation now work for all of us, so plus including me and you.
Nigeria, make we unite against terrorism. The Federal Ministry of Information and Culture bring on this message.
NTA Tuesday Live, a network issue-oriented innovation talk show.
Thanks for staying with us. We're looking at reforms in the judiciary. At this point in time, let's go out with our cameras and hear what the citizens have to say.
There are three cardinal issues to this. Number one, the public office, particularly the political office holders, the position is so lucrative that the civil servant aspire to be par with the political office holder. That is why the craze to make it even, that if a political office holder is taking 500,000, a public servant who has his take-home pay, maybe within the range of 50 to 100,000, would like to have similar amounts, so that to cope with the demand push and his disposable income cannot contain. The second issue is the judicial system. Because of the legal maxim that justice delay is actually justice denied, then the corrupt officials find an escape route to always connive with the judiciary to keep on delaying the adjudication of justice so that it will be hands up. Then the third issue, which deals with the entire cultural foundation of the society. Here we are as a nation that we tend to lean into the caricature civilization of the Western world, forgetting our internal dynamics of cultural antecedents, which dictates truthfulness, honesty, and integrity.
As you can see, things are moving. The way they are fighting the corruption is getting improvement. There is a lot of improvement in the corruption fighting. Yes. As you can see, they have recovered a lot of money.
There's an equity who says he who comes to equity comes with the clean hands. The judiciary itself, it is the best sector that it could handle and to deal with corruption cases. I think a special panel court has been set in order to look into this matter to avoid long periodic time frame of cases. And I think that way it will really help in hastening, in fasting the justice by bringing the corrupt public officers to account, or probably to bring them into justice. So when that is done, I think, one thing Nigeria believes in seeing example. When a top government official is being prosecuted for a crime he committed in looting funds, it will serve as a deterrent to many others.
Somebody may steal 1 billion, then the person can hire a son, hire a good lawyer that will go to court and pay millions. Then you recruit charge and bail lawyers to follow that same son to go and prosecute looters. It's not possible. It won't happen. In the court processes, they used to give sons priority. They used to give them respect in the courts. These things has been there. So the government should budget more money to these agencies.
Thanks for staying with Nigerians speaking out there, and particularly the last respondent there had perhaps Mr. Alege would like to respond to that last.
Impressions. Even if you have a battery of 100 senior advocates and the law is not on your side, it leads you nowhere. In any event, the prosecuting agencies nowadays themselves are employing senior advocates to prosecute on their behalf. So that old thinking that, the senior advocates are only for the defense is no longer correct. They are now working for both parties. And law is determined on cold facts. If the facts are not there, there's nothing you can do. If you botch the investigation and you present your prosecutor with incomplete documentation to win your case, there's nothing he can do, even if you have 100 senior advocates. And if I'll take you back a little bit into the reform agenda again and how the work is going on, I know that in the recent past, lawyers who have brought, to answer that question you're asking, who have brought frivolous appeals on behalf of their clients have been asked to pay costs personally. And I know recently, a senior advocate of Nigeria was asked to pay 2 million, 1 million for each of the respondents in an appeal because the issue he took up had been determined previously, and he just kept trying to see if he could change the angle of the argument. And the court came, and I mean, I'm not picking on him, he's not the first one. It has happened repeatedly. So if the case is so manifestly unsupportable, the law is so well settled. For example, jurisdiction in election matters for House of Assembly, House of Reps, ends in the Court of Appeal. And yet people will brief you to go to the Supreme Court. Like the last man said, and they pay good fees. So the lawyers get probably tempted by the good fees paid, because no lawyer on his own will prosecute an appeal on behalf of somebody to the Supreme Court. It is the pressure. There's a story we always tell, you know. A judgment was delivered, and counsel phoned his client. So judgment has been delivered and justice was done. He said, please appeal. He said, no, you won the case. So that is just the trend. But the point I'm making is that the judiciary is working with the bar, and conscious steps have been taken. So if you have that kind of a situation where the case is so manifestly unsupportable and you are swimming against the tide of the law, apart from striking out your appeal, they now award costs personally to be paid by the lawyer.
Okay. We have a call coming through from Bauchi. Ibrahim is calling in. Hello, Ibrahim. Go right ahead.
Very much, Mr. Cyril.
Yes.
Yes. Yes. Thank you, Mr. Cyril, and good evening to the gentlemen at the panel. My contribution is on the issue of the lawyer's behavior when it comes to prosecuting matters both in civil and criminal cases. Mr. Agunkwade, a member of the panel, has started making contributions in the area of civil cases, but has not been allowed to land there. And now, I would appreciate where lawyers are filing interlocutory applications or interlocutory appeals in matters and stalling cases where you cannot be able to continue with the main matter in court. And the judges are afraid to tell these lawyers, finish your substantive case so that we can be able to take both the preliminary objection and the main body of the case to appeal. But they will not do that. Cases are stolen for many years. We are noticing all this throughout the jurisdiction. I think that lordship should be able to speak to their colleagues, to surmount some courage, to be telling lawyers that, look, go ahead to the substance of the case so that at the end of the day you can appeal on both the interlocutory appeal and the substantive appeal. So I hope in the course of the discussions you can understand there is issue of probity, there is issue of honesty on the side of the lawyers who do not have the courage to tell their clients that if they are not on the right side of the law, that they are not right. So we have issues of conscience. And I don't know whether the law school or anybody can be able to teach anybody that. I think it is our fear of God that is getting lesser and lesser every day. I pray for our lawyers, honestly, because as long as the lawyers do not support the courts to do what is right, there is no way our courts can make any headway in the cases that are before them. I hope our learned senior advocate will stand firm and call the spade, and tell lawyers they should be up and doing, because it is only when we have good men at the bar that the judiciary can be able to perform better. Thank you very much.
Right. Thank you very much.
This issue of civil matter being talked about.
Right.
Reforms are going simultaneously in civil trial just as it is in criminal cases. Many jurisdictions now, by virtue of the provisions in the civil procedure rules, they have what is called settlement week. Now what that means is that all cases in the civil matter will be collected and sieving exercise will take place, so that cases that are amenable to amicable resolutions, which is faster, those that have court-connected multi-door courts, they refer those cases to the multi-door court for mediation, conciliation, or even arbitration, as the case may be, in order to fast-track the resolution of those disputes in civil matter. That hastens the process of disposal of these civil cases, just as the improvement in criminal trials are also taking place in most jurisdictions today. Just last week, Kano State constituted a committee for the purpose of adopting and domesticating the Administration of Criminal Justice Act. And I know, as a fact, most jurisdictions now are on front-loading, which is a departure from the hitherto long period of presentation of cases in court. So we are moving forward gradually in order to improve systemically the procedures in terms of adjudicative responsibilities and training of judges, magistrates within and outside. It's a daily thing, a daily affair, just to improve the skills. And we hope that the prosecution, the investigatory sectors too, will have similar exposition.
All right, yes.
So we have a lot to talk about, but it appears we don't have much time.
No. The time
really, I was trying to brief the House, or rather, Nigerians, on that we should not, it appears we are over-concentrating on criminal matters. And I think the bulk of the cases are civil.
Yes.
And we must be sincere with ourselves. There are aspects where lawyers are to be blamed. We have to be frank with ourselves. It's over 37 or 35, 37 years in practice, I should know. Consecutively for 26 years, I was in practice all over. Before I went to government, the expense came back again. So we all know what lawyers do. Some lawyers are not sincere, they are dishonest in their approach. They even advise their clients that, see, we must fight this thing on. Don't bother, I know what to do. It's a fact. Because you see, I used to boastfully, I would tell my colleagues, say, I know all you can do. I have it on my fingertips. I will go beyond you, beyond you. Before you get there, I already know what you want to do. Because you see, even where the client wants to settle, they say, no, don't settle. In a very clear case on defender list, the documents are there, the checks are there, and everything, and you are not admitting, you are still filing notice of intention to defend. Then after judgment, you go on appeal, a very clear case. So how do you want to exonerate the lawyer in such circumstance? It's lack of conscience. Because, you see, they exploit the rules of courts to the disadvantage of administration of justice. That is just the problem. And, this clamor, the judges too have a role to play. I know of judges, especially my Kano days, Justice Roland, Justice Ubonu, and these are men, Justice Dahiru Mustafa, who later became CJN, they'll look at you with your papers. That's it. Ubonu will remove his glass and put it down. Mister, I've seen what, can you see this? You think you can come in here and do me like this? I'm going to give judgment on defender list. Your client, when he was collecting this money from the bank, he wasn't, I think he's still alive. He's an Igbo, very, very articulate, very godly judge. He said, if you like, go on appeal. I'm going to give judgment now. And while we are standing here talking, he's already writing his judgment on the final list. Okay. So, we have, just like Justice Roland too. So I think the judges can come in at appropriate times to checkmate the exercise and mischief of lawyers. I will call it mischief.
All right. Okay.
So when there was a caller who talked about senior advocates, we all know it as a fact. Some senior advocates, they exploit that position to the disadvantage of their junior ones.
All right.
Because most senior advocates, no, not some of them, I'll put it that way, with respect to not so many of them, and I respect them. senior advocates, they have spent so many years at the bar. Naturally, they must be close to the judges. Some of them are classmates to the judges, friends to the judges, which is normal. Like I will put in about 35, 37 years in practice. I should know virtually everybody at the bench.
Oh.
If it's not everybody, at least most of the judges, because one way or the other, it's either at practice before you earlier or whatever. So what I'm saying in essence is,
you see, it is the smiling teeth that bite.
Exactly. So
it does not matter.
That's what I'm saying. That's what
I can sit down and dine with.
But the point is that because they are close, because they are close to the judges, doesn't mean that they will pervert justice.
Okay.
No.
All right.
It's a different thing.
Sometimes it's good to put these things that way.
The public will not see that way.
All right. We'll come to that in a minute. Let me just take it. Joseph is calling in from Lagos. We'll come back to that. Joseph, are you still there?
Hello.
Yes, go ahead, Joseph.
Good evening.
Good evening.
Yes, I don't have a little contribution to make towards the discussion. And my contribution is, I want to go back to the case of Ibori and Oboru. I'm sorry to say that our judiciary, the corrupt system that is going on in the judiciary, is something that we need to really address in this country. Now, in the case of Ibori and Oboru, there was a case, and yes, it was established that when James Ibori was actually convicted, and then they came back to say that they want to go back for identification, and someone else stood to say that he was James Ibori, but not the governor, but not the James Ibori, who was then the governor of Delta State. So, in the case of that magnitude, I am sorry to say that we need a thorough clean-up in the judiciary. The same Ibori was taken to court in London and was sentenced and jailed for many cases. So what I'm trying to say is the corrupt system in the judiciary should be addressed. They are there speaking grammar to all of us there because we don't know what they are there. This kind of English is to all. But I'm sorry to say that we need a thorough clean-up in the judiciary. Thank you.
All right. Thank you very much. What you're advocating is that the system should be strengthened so that we can all get justice. But again, let me come to another side of it all and just find out how well these reforms will address a certain phenomenon that for a long time had been quite visible. And this has to do with political cases where you find there's a case in court, a judgment is given, and someone goes to another court of cognate jurisdiction and gets a different judgment, and it keeps happening. How well with this?
Well, I think under the leadership of the present CJN, this is being addressed. Some judges have been removed for allowing this type of sharp practices to have happened. If you are aware a case is pending in one place and probably judgment has been given and you rush to another state and file similar things, and the petition, the council will ask you whether you are not aware of the procedure of the rules and the law. So if you are aware, why did you do that if you don't have invested? If you are not aware, then you are not fit to be on the bench, and some people have been removed. I think the perception is not as bad as, the situation is not as bad as the perception of the public. But I know with time, and with this reform agenda, everything will come back to. But the three arms of government, they need to work together in tandem as advocated by the CJFCT. There must be a forum whereby the three arms of government leadership should meet. Because we're serving country. When they say government, people think it's the executive alone that is the government. It's the three arms of government. They must come together in the overall interest of the Nigerian citizenry. And how do we forge ahead? If law is to be made, the executive prepares the bill, sends to the National Assembly. The judiciary is not aware of the policy trust behind that bill. By the time the law is enacted, we interpret it in accordance with our background, the training, and the public will now say this is the court. If you are not able to prove your case, you are not able to prove your case. Let's even fall. justice must be done.
You see, it takes knowledge for one to know that a matter had once been adjudicated upon.
Yes. Okay.
If a matter is brought to FCT judiciary, there is no how I would know that it was adjudicated upon as the Federal High Court or a court in another state, unless the opposing counsel raises it on the floor of the court, drawing attention of the presiding judge who superintended over the matter. It is only at that point we will come to know that, oh, this matter had already been decided upon, and therefore he does away with it as incompetent, having been adjudicated upon. But you see, what they normally do is, if the parties in Federal High Court were Abu, Salisu, John, they will remove John and then come to FCT High Court, and they say they're different parties. But the subject matter, the reliefs are the same. And in such a situation, there's nothing you can do.
Absolutely.
I'll check this call, then I will ask the senior advocate why lawyers would do a thing like that. But let's hear from Zachary from Jalingo. Hello, Zachary.
Yes, sir.
Yes.
Mr. Cyril, good evening, sir.
Good evening.
Well done, sir.
Yes, go ahead.
Well, please, I want to bring to the attention of the panelists that judicial reform should not only be concentrated at the High Court and the Federal High Court, the Court of Appeal and the Supreme Court only. Judicial reform should trickle down to the last court of the land, particularly the area court, the magistrate court, all those lower courts. A lot of things are happening down there. And the common man, the poorest of the poor, they go to these are the courts they can access. And they need to also put enough reforms at that level that will also take care of the interests of those masses who are closer to those courts and who always access those courts.
All right. Okay. Okay, thank you very much, Zachary. We'll note it down, and we'll go to that just after Mr. Alege comments on this issue that we raised just before we took the call.
Well, I first want to start with what Zachary has said. To say part of the reform that is in place currently, there's performance evaluation for officers, which is handled by the NJC, but the current CJN has now trickled that back to the CGs of the states to ensure that they also do performance evaluation. They have court inspectors that will deal with the lower courts, because those lower courts report to the state judicial service commissions, not to the NJC. So there's no way the NJC can go down and supervise and know what is happening at the magistrate court. So part of the reform that is in place now will address what Zachary has just raised. The other issue I would like to address quickly is the issue of civil matters and litigation.
Okay.
You know, now with the Administration of Criminal Justice Act that has been domesticated in all the states, and with the passage directions to ensure speedy trials of criminal matters, kidnapping and corruption matters, we expect there to be speedy dispensation along those lines. For the politicians, they have taken care of themselves. They've gone to the Constitution and they put 180 days. So their own cases must be heard 180 days. And now there's a clamor for the other 80%, the civil cases. In all we discuss about speedy trials, we fail to look at the basic rudiments of a speedy trial. Is the judge well remunerated?
Right.
Does the judge have lights? Does he have NEPA lights to write his judgment? I have gone to high courts where they don't have roofs, and the judges are expected to perform miracles. We compare ourselves with the UK, with America. There no judge writes in longhand. stenograph, which is the type, is now old and outmoded. They now have digital recording devices that as soon as the judge rises, the whole record of proceedings is before him. If you go before my Lord, as you are talking, he's writing. If you speak to say, slow down, Siri, I can't hear you again. How can the trial be fast? And then think of the health of the judge, who has to sit down and call each case and record everything you say. Yes, what's your name? Siri, spell it. Stoba, yes. And he has to write all that down manually, day in, day out, for a docket of 50 cases, 30 cases. If we do not address the infrastructural deficiencies in the judicial system, we have done, like my Lord said, we've done front loading. But after you do that front loading, the judge still has to come and record you adopting. And then he has to go back home and read by himself. How many of our judges have research assistants? We compare ourselves to other jurisdictions. We should ask, what have they done in those jurisdictions to ensure that they are speedy trials? They have judicial research assistants who, as you are bringing all this, your written addresses, are sifting the issues and drawing the attention of the courts to the relevant authorities. The judge has, the judge doesn't know the price of diesel. I've seen judges with jerry can in petrol station looking for petrol to buy to enable them to deliver a judgment the next morning. And the people who is going to are abusing him, that he's coming late to court. They don't know that the man was driving around in his personal car with part of his salary to buy petrol to point to his I better pass my neighbor generator to enable him to write a judgment. There are challenges in the system. We must address these deficiencies. We have a concern that provides that the money that is due to the judiciary should be paid to the judiciary. But what happens in essence is that in the federal government is doing very well. They do their best to fund the judiciary. But to the best of my knowledge, the budget for the judiciary has been stagnated at, I think, 73 billion for maybe 5-6 years. I don't know if that's been increased now. Increased recently. In the states, it's a totally different ball game. The governors decide, for this month, CG, I'm giving you 500,000. That's all I have for you. And they expect to use that money to deliver speedy justice. So if we do not look at the intrinsic problems in the system, with all the amendments we are doing to the rules, with all the good efforts we are doing, which is why we keep saying it must be a collaborative effort. The executive, the legislature, the judiciary, the lawyers, and Nigerians themselves. People must learn to accept defeat. You must learn to say, the facts don't support me. And no matter how a lawyer pushes you, I agree, lawyers err. But if you're the one going to pay a fee to a man who is convincing you, you know you don't have a case, and he tells you you have a case, say, no, I don't have a case. Leave it. I agree, I have lost. What we keep doing at the bar, I have drawn attention. Now the judiciary is imposing personal costs against lawyers. The other angle which I would encourage judiciary is for the judges to report those lawyers. Yes. Whenever, and I stand to be corrected, a judge in his judgment says, this lawyer has misconducted himself in handling this case before me, and the lawyer goes to the Legal Professional Committee, the lawyer is sanctioned. Yes. And wherever it is drawn, whatever infractions of lawyers are brought to the attention of the Nigerian Bar Association, the matter is dealt with speedily. But where you do not raise these issues, there's no oracle in the Nigerian Bar Association. The Legal Professional Committee cannot on their own go and pick lawyers and charge them by themselves. There must be a complaint. So we keep encouraging, make complaints, let us be aware, and this issue will be addressed.
One of the callers talked about allowing these reforms to trickle right down, so they shouldn't stay up at you know, at the superior courts. What has been your experience like at those lower courts that he's been talking about?
The lower courts, I think with the magistrates, the area courts, customary courts.
Yes.
I think a lot needs to be done there. because, like for instance, in the magistrate court, we have police prosecutors, and the policemen are not they're not knowledgeable in the law. At best, maybe they know the penal code.
Well, as head of court, I can tell you, in the FCT, we no longer tolerate lay policemen to prosecute. The very day the Administration of Criminal Justice Act came into operation, lay policemen ceased to appear before any court in the FCT. Any policeman that appears as a prosecutor, he must be a lawyer, duly called as an advocate of the Supreme Court of Nigeria to the bar. That is one. Two, in terms of reforms at the lower bench, before I became the head of court, I presided over various committees enhancing or extending the jurisdictional powers of the magistrates, both in civil and criminal jurisdictional powers. Some of the system that afflicts the proceedings, starting from the magistracy to the High Court, were done away with. That is PI. What that means is preliminary investigation. It is provided in the CPC for good reason, for ideal reason, but it's being abused. In capital offenses where the magistracy does not have jurisdiction, they conduct preliminary investigation, and where there is a prima facie evidence, then they move the case to the High Court for trial. But this has been abused, and we have done away with that. And such cases no longer go before the magistracy. They come directly to the High Court.
All right.
To eliminate such delays. We also have removed criminal jurisdiction in area courts, in the FCT, except those who are called to the bar as lawyers, as upper area court judge, or principal area court judges, or whatever grade. So long as you are a lawyer, you are conferred with criminal jurisdiction because of the abuses. And even then, we subject them to thorough training so that they understand procedurally what is expected of them as judges exercising criminal jurisdictions with the FCT.
These are in the FCT. Yes. Beyond the FCT, in other states.
That is, especially, we're talking of the states.
Yes.
The FCT is doing wonderfully well.
Right.
But we have 36 states with the FCT. In most of the states, we don't really have justice and good justice administration in the states, especially the area courts, magistrate courts, customary courts. When you get to some area courts, you wonder that is this a court? The judge will just sit down. Sometimes you share cooler nuts, even with people, court at maybe the registrar. They laugh and joke. In fact, you will think you're in your house. So you see that element of seriousness is not there. And if you are unfortunate,
in my assignment, the congestion in the Nigerian prison, already I have identified some states where these abuses are predominant at the lower bench. And the statistics of those detained on minor offenses already at my fingertips. Okay. And soon I'm going out with the team, and we're going to address this kind of problems from those areas.
We're fast running out of time, but there are two issues I'd really want to raise. One of them, just Dijuma, and this also is, yes, it's been said that the judge acts on evidence presented in court. But when it comes to pronouncing sentences, sometimes, I'm sorry I use this word, the public has been outraged about certain sentences. I know my Lord talked about sentencing someone to 1 day, and that is that's punishment enough. But there are certain cases that go to court. I want to give an example of rape, for instance. And at the end, the accused person is convicted, and he is given what people call a slap on the wrist. And when you question it, they say, okay, the law provides for a maximum sentence, or sometimes a minimum sentence, a sentence with a fine or without a fine. Why would a judge, in cases like that, determine to use the minimum sentence?
Well, in Syria, you see, this issue of sentencing depends on the judge and the law. at times the law gives him the discretion to choose between one or the other, and he must take many things that have happened during the procedures into consideration. So for that, you may not crucify the judge. Depends on the type of law he is trying to interpret. And because then, it's not limited to criminal matters alone. For instance, I know what you are indirectly referring to. There was a time a judge gave judgment and awarded lower punishment.
Yes.
To me, that is not the fault of that judge. If a prosecuting agency decides to charge an accused person under a law that will give him lower punishment, instead of charging him under the one that will give him something higher, and the judge looks at the law and applies that law, we cannot crucify that judge. This depends on that.
Sentencing has its own sciences. There are parameters that a judge or magistrate or a judge of whatever cadre or category should take into consideration, depending on the circumstances. Where somebody is charged with an offense and he pleads guilty, procedurally, he attracts leniency. Now, that is why the public tend to think, oh, everything is like this with the judiciary, because you don't know what is there. The training is that once somebody pleads guilty, confesses without wasting the time of the court, even when this governor we're talking about, Ibori, was convicted in overseas, the judge says, but for the fact that you have confessed, the punishment would have been stiffer.
Yes.
That is the procedure. It attracts leniency, and even confession. The judge you are talking about, there was plea bargain. It is the duty of the agency to tell the public how much was recovered in terms of liquid cash, in terms of property, so that is after they had backpedaled and substituted the charge with the earlier charge with a lesser charge that gives the judge the option of fine, to give option of fine, which of course he exercised, in my view, rightly, taking into consideration the parameters of, one, there was plea bargain, a lot of money recovered from the defendant, a lot of property recovered from the defendant, which was not made. I was engaged with a banker in a discussion of that matter. And he went on saying, oh, the judge should have taken the tempo of the public. I said, okay, you are a banker, let me go to your field. If somebody, there's famine, and people are clamoring to go back to the farm, and they come to you for agricultural loan, I can tell you I was once seconded to a bank, so I am talking with authority and competence. I asked him, if your lending authority is from 100,000 to 500 million, and somebody comes looking for 25 million, because there's famine, are you going to take into consideration the tempo of the public and go beyond your lending powers? He said, no. I said, that is the position of the judge. Cannot go beyond what the law has provided for him. He works under the law, and he works by law as the judge. So he had taken the parameters of the plea bargain, all those things that have been gotten from the suspect, and then rightly gave him option of fine. This is discretion. I had put down, for the purpose of attaining some relative what do I call it, consistency, sentencing guideline in the FCTC. It's a whole book, sentencing guideline, in order to attain some kind of semblance of uniformity or consistency in sentencing guidelines. But it doesn't take away the discretion from judges.
All right, starting to say that justice has not only been done, but must be seen to have been done. So that's an important aspect. And when the public says this, and they refer and say, well, you say you are the professionals, you are the learned people who say justice has been done, but we don't see that it has been done, in quotes, the fact that we think that this should have attracted more.
Yes, You may think so, but law is what the law says. And if you go outside the law, definitely justice has not been done. In that case, injustice has been done. And again, it comes back to the same position we keep saying. There must be collaborative effort. In other climes, what happens? They say, for this law, let us take the gun law, for example, in some states in America. You have a gun without a license, the fine is defined in the law. If you use the gun, the sentence is defined. If somebody gets hurt because you use that gun, the sentence is defined. If somebody gets killed, it is defined. So if it's your brother, your best friend, and he kills somebody, the law already specifies the penalty. So that's what they've done on that jurisdiction. But here, when we give a judge discretion, he must exercise the discretion based on the facts. Like he said now, my lord has said, money was recovered, a plea bargain was done, property recovered. The most important thing that you must note in all he has said is, was this made available to the public?
Right.
At the time the public were saying the judge has done something wrong. No. Could the judge address a press conference to explain himself? No.
All right. We're in the final few minutes of this, and I'll just ask Tumbas Gukwadi. Well, this, of course, is probably a straightforward thing, and part of the reforms, of course, will include the welfare of judges, and that also has come on the question, and it's been raised here that is the judge comfortable? What does he earn? Well, other Nigerians will say, how many Nigerians earn a living wage? But judges are in a different category. So in terms of the welfare of judges, what would you like to see quickly?
The learned son had spoken extensively about that. Maybe what is obtainable in other climes, where we have better administration of justice, should also be applied to them.
Right.
Especially the recording system.
Yes, the use of technology.
Yes, it's very important so they have the documents.
It's part of the reform agenda of the CJN. It's there, it's pursuing it very well.
Then again, it's also important, even their security too should be addressed appropriately. Then other allowances, perquisites that could make them very comfortable. It's because when people say they bribe a judge, you can only bribe a judge who is not comfortable, who has some pressing needs to attend to.
Man.
But a judge who is very comfortable in terms of what it takes, probably some allowances for education, because they are doing a wonderful job. Their life is at risk, their time and everything, even old age and whatever. By the time they leave the bench, you know, it's not much they can do again, because they've really been saturated. They will just sit down, probably come out, sometimes sit at the top roof and, you know, try and have some. So they need to really be adequately compensated. It's very important. You see, and there's this aspect of administration of justice, you know, reform, which we should look at too. There's a lot of poverty in the country.
Right.
Ignorance too.
Right.
So a lot of people, apart from criminal matters, in civil matters, a lot of people don't even know their rights. So there's no awareness.
Okay.
Even where they know the money is not there to prosecute their civil matters when their rights have been infringed. So something should be done about that.
Okay.
So these are some of the.
Well, just unfortunately we've run out of time, but there was a question that was specifically sent in by mail, and this was directed to the Chief Judge of the FCT. I had saved this for the last because it probably would take him a few minutes to comment on that, but maybe I'll just give it to you straight now, because in a few minutes, I don't really know, but here it is. It's from Ben Shamang. He says, what is the Chief Judge of the FCT doing regarding Abuja Environmental Protection Agency that arrests hawkers, do mass trials late in the evenings, and pick those accused to Gwagwalada over minor offenses like hawking?
Very well. On this I know I discussed with the Honorable Minister of the Federal Capital Territory and a person that is well disposed to all the issues that we have discussed on that. When I got the information of the manner young girls are being squeezed, thrown into vehicle, and asked to pay fines 5,000 when maybe the granite is not more than 200 naira. Now, what I told the Honorable Minister, FCT, which he agreed with me, at a point I withdrew all the magistrates. I said until they are able to make amend before I will reinstate them. I said, some of these hawkers going about with granite 200 naira, they are not even the children of the owners of the granite. They are children of people who are more downtrodden in the society. They are just hired to go and hawk this granite, and when they are trampled upon by the officers of the Environmental Protection Agency, they are thrown like rags into vehicles, moved around with them to their offices, locked them. I don't know who authorized them to have their own lock up, and all sorts of ill treatment. And we went further, told him when he's going to his office, let him look under the bridges in FCT and see the kind of young ones lying down there. Some of them are children from responsible families, and even if it is otherwise, they are Nigerian citizens. What we require is not to mock them when there is any hint of possible insecurity and that they are likely to be used as the striking point or the triggers. Then they are mobbed around by security agencies. Sometimes their age is hiking so that they can gain admittance into the prisons.
Right.
What we require, and soon after they are put into the prisons, the prison authority will start experiencing threats for riotous situation in the prison, and then the press will take it, the courts are decongesting the prison. So I told him, the best thing is to have a standard rehabilitation center in the FCT. When you mob these people, put them there, let them get rehabilitated, and then we then relink them with their family members. I went as far as telling him we have project for building family courts, and there is need for what do you call this, hostel homes,
yeah.
all right, and then children and young persons court. He agreed he's going to do all these things. All right. In fact, even building the family court, the children and young persons court for us, where I have made provision for a unit for peace and reintegration of family members with their children rehabilitated, and even family disputes.
All right.
So we are already doing something on that, okay. And the minister, I have reinstated the magistrates, okay, because we have arrived at understanding that there will be more civility in handling the situation.
All right. Well, as I always say, no one program can take care of all the issues, and we must leave this discussion here, and do hope that sometime in the future we'll be able to take another look and see just how far the reforms, which have already started, have taken root. But for now, I would like to extend appreciation to our guests. Like I said at the beginning, for me, it's a first. I've not had to sit down with a serving judge on a program like this and interact. And, so, to Justice Babatunde Adejumo, President of the National Industrial Court of Nigeria. But thank you very much for being here, my Lord.
Thank you.
Thank you. And my Lord, the Chief Judge of the FCT, Justice Ishaq Bello. It's been a pleasure having you with us. And for the former President of the NBA, Member Corruption, Financial Crimes, Cases, Trials Monitoring Committee, Mr. Augustine Alege, Senior Advocate of Nigeria. Thank you for being here.
Thank you very much, Cyril.
And also, appreciation to Otumba Sonya Ogunkwadi, now in legal practice, having served as special assistants to a former national security advisor. Well, thank you for.
Thank you so much for having me.
Right. Thank you so much.
And so thank you too for being part of this program. Next week we'll reach you again on NTA Tuesday Live. I'm Cyril Stober. Bye for now.